Hi, I'm Heather Kimmel, the General Counsel of the United Church of Christ. Welcome to our webinar on the Families First Coronavirus Response Act. We're focusing today on how the Act affects churches, and all are welcome to attend, regardless of your church's affiliation. Just a little bit of housekeeping before we start. In the left corner of the screen, you'll see the chat function. I would love it if you would just type in your name, your church's name, and the city and state from which you're joining us. I'm, of course, coming from my home today, where I'm practicing physical distancing like many of you are. I'll be joining you in the chat live during this broadcast to answer questions that might come up. I'd also like to thank the Insurance Board for their help in putting this webinar together. While I'm going to do my best to answer your questions about the legislation, I cannot give legal advice specific to your church or about your specific situation. I can act as your church's attorney, and if you have a question about how the legislation applies specifically to you or your church, I recommend consulting with your church's attorney or with your personal attorney. I also need to say, this is brand new legislation that we're dealing with. The Department of Labor has been pushing out new guidance on this law almost daily. For reference, this was recorded on March 27th. While no regulations have been issued yet, we can expect the Department of Labor and the Internal Revenue Service to continue to update its guidance frequently. This makes it really important for you to check the websites of these government agencies for the latest guidance and regulations, as well as with your legal counsel, to be sure that you have the most recent interpretations of the laws. Please also know that today's webinar will deal only with the Families First Coronavirus Response Act. We've received a number of questions since we announced the webinar about the new stimulus package and unemployment. I am not going to be addressing those issues today. This webinar is designed to address the provisions of the Act that most commonly affect churches and other religious organizations. The Act has other provisions that apply to organizations like healthcare providers that we are not going to be discussing today. I'm going to cover the Act in general first, and then we're going to take a little bit of a deeper dive into what it means for churches and how churches can comply. The Act really implements two major changes for employers. The first is that it requires paid leave for parents who are unable to work, either at their place of business or remotely, because their children's school or daycare is closed due to a public health emergency related to COVID-19. The second is that it requires employers to provide paid sick leave on top of any other sick leave already provided by the employer, but only for specific reasons related to COVID-19. Employers can take full payroll tax credits for both of these types of paid leave, and if the amount that the employer pays in leave exceeds the payroll taxes that the employer owes, the IRS will send the employer a check for the difference. The Act applies to leave that is taken between April 1st, 2020 and December 31st, 2020 for only the reasons that are specified in the law. It's not retroactive. So for example, if you have an employee who's been unable to work for a couple of weeks now because their child's daycare is closed, or an employee who's already taken time off to be tested for COVID-19, the Act is not going to apply to that time they have already taken off. It only applies to leave going forward starting April 1st. The Department of Labor has issued guidance stating that it's not going to bring any enforcement actions against employers for the first 30 days that the law is in effect, so long as employers are making a good faith attempt to comply with the law. Instead, the department is going to focus on compliance assistance during this time. So the big question here, especially for churches, is who does this act apply to? The Act applies to employers affecting commerce that have fewer than 500 employees. The fewer than 500 employees requirement is a big change for the FMLA provisions because the FMLA ordinarily applies to employers with 50 or more employees. Congress has made these provisions applicable to employers with fewer than 500 employees, which includes employers with fewer than 50 employees. We now have many churches whose employees will be covered under this FMLA provision that will not be covered under previously enacted FMLA provisions. The Department of Labor has yet to issue regulations on the Act, and certain provisions may not apply to employers with fewer than 50 employees. We just won't know what these provisions are until the regulations are issued. The Department of Labor has said it will issue regulations in April. Additionally, the Act applies an exemption from the FMLA provision, but not the paid sick leave provision, for employers with fewer than 50 employees when the requirements of the law would jeopardize the continued ability of the business to continue. The Department of Labor will also be establishing a process for that exemption, and I'll cover that shortly. Many churches, of course, are going to want to know if they are affecting commerce, and I'm also going to cover that piece in just a little bit. A big question we've been getting is, do these laws apply if I already give my employees paid time off? So I know that many state and local leave laws that are being enacted around the country do not apply if employers already provide a certain amount of leave to their employees. This act is different. This leave is required to be provided on top of the employer-provided leave, and an employer cannot force an employee to use employer-provided leave before using leave required by the Act. So for example, if you already provide 40 hours of sick time to your employees, you will still be required to provide an additional 80 hours of sick time for the reasons provided under the Act. This is also on top of any leave you may be required to provide under state and local laws, so be aware of those leave laws as well. Okay, the first big question for churches is my church engaged in or affecting commerce? Whether your church is engaged in or affecting commerce is a facts and circumstances inquiry. Courts have been really clear that commerce includes both for-profit and not-for-profit operations, and that it can include church operations. Courts have interpreted affecting commerce very broadly, which means that a minimal amount of commerce-related activity by a church could be enough to meet the requirement. The answer in any particular case will depend upon how narrowly or expansively a court construes the term affecting commerce, and upon the size of the church and the nature of its operations. So here's my warning to you. Never assume that a church does not satisfy this requirement without legal advice. Churches may be exposed to substantial liability if they erroneously assume they're not subject to federal employment laws because they don't meet the commerce requirement. Here are some factors that indicate a church may be engaged in or affecting commerce. If a church is operating a school or a daycare or any business, there's a high probability that that church is affecting commerce. Courts have also held that a church operating a camp attended by out-of-state campers affects commerce. If your church is conducting business across state lines or is using broadcasting on the internet, television, or radio to do its ministry, like many of our churches are right now, that may be enough for your church to be engaged in commerce. So many of our churches likely are engaged in or affecting commerce. Now that we've covered the employers that are subject to the Act, let's first talk about the new Family and Medical Leave Act provision that gives paid public health emergency leave. All employees who have been employed at least 30 calendar days are eligible to take this leave. For those of you who are familiar with the FMLA, the usual requirements that the employee must be employed for at least 1 year and must have worked at least 1,250 hours do not apply here. This law is going to cover full-time, part-time, exempt, and non-exempt employees. And unlike normal FMLA, which is not paid, this leave is paid. So there is only one reason that an employee is entitled to take public health emergency leave under the Act, and that's if that employee's child, which is defined as a child under 18 years of age, is unable to attend school or daycare because the school or daycare is closed due to a public health emergency with respect to COVID-19. There's no other eligible reason for paid leave under this provision. If you have an employee with a child home from school, that employee may not be able to work even if they have the option to work remotely because of their responsibilities relating to childcare. This law allows them to take paid leave under those circumstances. Employees eligible to take paid public health emergency leave can take leave for up to 12 weeks. The first 10 days are unpaid, but the employee can elect to take employer-provided leave during those 10 days, or they can elect to take the 80 hours of paid sick leave provided by the Act. That's what gets the employee to 12 paid weeks. Employees are required to give notice, but there's no particular form for that notice. The only requirement is that that notice be provided as is practicable. So how much pay are employees entitled to? It's not full pay under this leave. Employees taking leave are after the first 10 days, which remember is unpaid. They're entitled to 2/3 of their regular pay per day, up to $200 per day, with a cap of $10,000 in the aggregate over the 12 weeks. Some employees will choose to be paid for that first 10 days using employer provided leave because it will provide full compensation. Some will choose to use paid sick leave under the Act, which we will talk about shortly. For part-time employees, you calculate the leave entitlement based on the average number of work hours per day in a 2-week period. If their schedule is variable, you can use a 6-month period. If they haven't been working for at least 6 months, the Department of Labor provides additional guidance on how to calculate that average. There are some exceptions for complying with this law for some employers. The Act does say that if the continued viability of a business is threatened because of the FMLA requirement, the employer can apply for an exemption. Current guidance states that the employer will need to document this, and also that the Department of Labor will be issuing regulations for that exemption process. Remember that there's a fully refundable immediate tax credit available, which we will also talk about towards the end of this presentation. The Department of Labor may also issue regulations that exempt employers with fewer than 50 employees from complying with certain provisions. Remember that we just don't know what those are yet. That guidance is expected in April. It's also worth noting that if an employee takes leave, the employer must restore them to a like position. Although there is an exception for smaller employers if the position no longer exists because of COVID-19, but that employer does have to make reasonable efforts for up to a year to reemploy that employee. We're going to move on to talking about the paid sick leave provisions now. Unlike the FMLA paid public health emergency leave provision, the paid sick leave provision applies to all employees, regardless of how long they've been employed. Full-time employees can take up to 80 hours. Part-time employees get the average number of work hours in a 2-week period. That's calculated the same way as the average for the FMLA provisions. You can require the employee to follow reasonable notice procedures after the first day of their sick leave under this law. Paid sick leave is only available for limited reasons under this law. The first 3 reasons have to do with the health of the employee. And the first reason is that the employee has been directed or ordered by authorities to quarantine or isolate related to COVID-19. One question that I've been getting is whether these shelter-in-place orders that many of us are under qualify as quarantine or isolation orders. No regulations have been issued yet that further define quarantine and isolation orders, but these orders relate to having been exposed to or actually having the virus. That's different than the stay-in-place or shelter-in-place orders that many state governments are issuing. It is likely that a shelter-in-place order will not qualify for paid sick leave under the Act. The second reason to have paid sick leave under the Act is that the employee has been advised by a healthcare provider to self-quarantine. And the third reason is that the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. The last 3 reasons do not relate to the health of the employee, but the employee is still entitled to paid leave for these reasons. The fourth reason is that the employee is caring for an individual that is subject to a quarantine or isolation order, like we described in number 1. And also note the employee doesn't have to be related to the individual. That is not specified in the statute. It's just that they're caring for that person. The fifth reason hopefully looks really familiar to you by now, and that's that the employee is caring for their child because the child's school or daycare has been closed because of COVID-19. This is how an employee who is eligible for the FMLA paid public health emergency leave is able to take paid leave for the first 10 days of the FMLA leave. They use the paid leave under the Act. Finally, the Secretary of Health and Human Services can also specify substantially similar conditions. The pay that employees are entitled to under the Paid Sick Leave Act is a little bit different than under the paid FMLA provisions. For the reasons that are relating to the employee's health, either quarantine or isolation order, advised to self-quarantine by a healthcare provider, or experiencing symptoms of COVID-19, the employee is entitled to their regular rate of pay, capped at $511 per day and $5,110 in the aggregate. For reasons 4 to 6, which do not relate to the employee's health, The rate of pay is the same as it is under the FMLA public health emergency leave provision. 2/3 the regular rate of pay up to $200 a day. And that, of course, is capped at $2,000 in the aggregate. Unlike the FMLA public health emergency leave, all employers must comply with this law. But there is the payroll tax credit to make this less expensive for employers, and I'm going to talk about that next. The intent of the Families First Coronavirus Response Act is to be revenue neutral. So for every dollar of qualified sick leave or family leave wages that an employer pays to an employee who's on leave, the employer gets a credit against the employer's payroll taxes. If the amount of wages that an employer pays to its employees who are on leave exceeds the amount that the employer owes in payroll taxes, the IRS will send an employer a check for the difference. The law also provides that the employer can take a payroll tax credit for amounts paid for the employee's group health plan while the employee is on leave. You will want to be sure to check that your health plan qualifies as a group health plan under the applicable Internal Revenue Code section. If you are a church in the United Church of Christ and your health plan is through the pension boards, it does qualify. We also expect the regulations to clarify whether it is the employer's cost or also the employee's cost that the church can take a credit for. So the payroll tax credit can only be taken for qualified sick leave and family leave wages. Ordinarily, for lay employees, that's going to be what they are paid on a regular basis. The Act defines wages by referencing the Internal Revenue Code provision that defines wages. So of course, I'm sure that most of you who are familiar with the unique tax treatment of ministers are wondering whether payments to your ministers while they are on leave will be eligible for the payroll tax credit. So the definition of qualified sick and family leave wages under the Act, by its reference to the Internal Revenue Code section, excludes ministerial employment from the definition of wages. So the church likely cannot take the payroll tax credit for payments to its ministers while they are on leave. Because the minister is a statutory self-employment tax employee, the minister can likely take advantage of a provision in the Act that allows self-employed individuals to claim the payroll tax credit. This, of course, would pay the tax credit to the minister and not to the church. I want to recognize and acknowledge that this is a really unsatisfying response for all of you who have that question. It's complex and it's unique. It is simply the result of legislation that is written without the unique treatment of ministers in mind. Right now, we don't know any more than that about how payments to ministers will be treated under the Act, and we don't know if regulations will clarify this or not. So I also know that many of you are wondering exactly how the tax credit is going to work for your lay employees. So I want to take a closer look at that. Ordinarily, a church pays the employer's share of Social Security and Medicare taxes for its lay employees. It withholds the lay employee's share of the Social Security and Medicare taxes, and it withholds federal income tax for lay and clergy employees. The church deposits these taxes with the IRS and files quarterly payroll tax returns with the IRS. Under the Act, if a church goes on leave, the church is going to retain the payroll taxes instead of depositing them, up to the statutory cap on the leave, plus the cost of the group health plan coverage. So if the church pays more in leave than it has in the retained Medicare, Social Security, and withheld federal income taxes, then it files a claim with the IRS and gets the rest of the money from the federal government. The IRS has stated that it expects to issue these payments within 2 weeks of making a claim. If a church decides to have a policy that pays the employee more than they are entitled to under the law for leave, the church can only take a credit for the statutory leave amount. And presumably, the church cannot increase the salary of its employees while they are on leave so that the employees in the church are paid more by the government. So in general, you'll want to be careful of keeping your records in the event you're audited or the Department of Labor investigates. I have an example for you that will hopefully make the payroll tax credit clearer. The dollar amounts on this slide are in no way based in reality. I highly doubt there are a lot of church administrators out there making $300 per day, but we can dream. So let's take for an example, a church administrator who makes $300 per day. That administrator goes on FMLA leave because their child is out of school. The first 10 days of that FMLA leave are ordinarily unpaid, but the admin elects to be paid under the paid sick leave provision on the Act for the first 2 weeks. Because of this, the admin is paid at 2/3 of their salary for 12 weeks, or $200 a day. At the end of 12 weeks, the church has spent $12,000 on salary for the administrator. Let's assume that the church has also spent $800 in paying the employer portion of the healthcare premium. Normally, on a quarterly basis, the church deposits about $10,000 in payroll taxes with the IRS. And that consists of the employer-employee portion of Medicare and Social Security and withheld federal income taxes. Because of the payroll tax credit for the FMLA leave, the church can retain the entire $10,000 and also file a claim for the additional $2,800 in costs associated with the leave, which it will hopefully receive within the 2 weeks indicated by the IRS. Government agencies, including the IRS and the Department of Labor, are expected to issue clarifying regulations and procedures soon. I'd also like to address a couple of remaining questions that we are getting. And the first is, can we pay our employees more than the 2/3 required by the Act while they're on leave? Many of our churches are incredibly generous, and to them, providing full compensation is a social justice issue for their employees. So the answer is yes. Employers can pay their employees who are on leave more than what's required by the Act, but the tax credit is only available up to the statutory cap on the wages. The second is, do we need to notify our employees of this new law, and how do we do that? Yes, churches have to notify their employees of the new law. Ordinarily, you would notify an employee of a new employment law by posting it in your church. We're not in our churches right now. So you can take the poster, you can download it from the Department of Labor's website, and you can email it to your employees, and that will count as posting for now. The Department of Labor actually has a question and answer section about posting on its website. Post it in your place of employment as soon as you are able to. There's also an anti-retaliation provision, which means that employers can't retaliate against employees for taking leave under this Act. So you can't demote or fire an employee who takes leave under this Act. And finally, the question is, what about record keeping? What records do churches need to keep? Employers need to keep records that are related to leave requests, especially if they intend to claim the payroll tax credit. They may need to provide this documentation to a government agency that relates to this. The employer should record the employee's name, the qualifying reason for requesting leave, the statement that the employee is unable to work or telework for the reason, and the date for which the leave is requested. You're also going to have to document the reason for the leave, such as getting the copy of the quarantine or isolation order or a note from the healthcare provider. It may include written documentation, such as a note advising the employee to self-quarantine due to the concerns around COVID-19. But keeping accurate records is really important because you may be asked to provide these by a government agency. This is all I have for you today under the Families First Coronavirus Response Act webinar. I really want to thank you for taking the time to attend this webinar. I hope it was helpful to you and your church. Please don't forget to check the Department of Labor's website for the most recent guidance, and please reach out to your attorney if you have further questions on your church's specific circumstances. Thanks also again to the Insurance Board for sponsoring today's program.